Crumpy, we can't hear you. Okay, folks, ladies and gentlemen, we are here. There is a Supreme Court decision on the Trump immunity. So, do presidents get immunity, some form of immunity, limited immunity? We will be answering that question momentarily as soon as John gets his audio back.
Can you hear me?
We hear you.
All right, awesome. Awesome. Go ahead and take it from here, Rich. I'll be right back.
All righty, Crumpy. So I'm going to spill the beans. I don't have the document in front of me right now because I would have to be a prepared host and not taking care of my dogs in the morning. So what's going on is the Supreme Court did decide that there is limited immunity to presidents. Now, you got to realize this is kind of like a massively intricate and chaotic thing going on because Trump was found guilty on 34 counts of whatever, which probably don't have any connection to this, that he's could be sent to jail after kicking Biden's butt in the debate. So let me bring up SCOTUS blog. And let's take a look at what we got going on here because I have only seen like titles of media reports. So let me pop this up here as we're going into. But what's going on, the brief synopsis that I saw is that President Trump has limited immunity. So I'm assuming the most normal thing this could be would be that Trump is not 100%, or I should say a president does not get 100% immunity. He cannot run around like a dictator doing crazy things. But as far as the day-to-day operation of a president, he has immunity from that. So, and as much as I'd love to hang Biden on things, because what's good for the goose is good for the gander, I want to make sure that we have a working republic for the future and that we don't have a banana republic. So that's what's going on here. All righty. So pulling it up. So give me a second here. Because I am not finding it on the SCOTUS blog. Oh, did it just pop? No, that's something else.
Sorry, I'm in a day meeting, but I'll bring it up for you, Rich.
Okay. You can get it up for me. I appreciate that.
Absolutely. Basically, what they said is in the official duty, the president absolutely does have immunity on things. And unofficial duty, it does. They do not have. They do not have immunity. But anything officially and constitutionally official duties, they have it.
So that's a big win for President Trump.
It's a
Again,
massive one for President Trump.
it's a sword that cuts both ways because I would have loved to have seen President Trump elected and then everybody else get prosecuted for the dumb crap they did. This is just like when the Democrats went after the filibuster, and then when the majority changed in the Senate, they're like, "Oh, you're not gonna, change the filibuster for appointees, court appointees, are you?" And it's like, "Heck yeah, we are. What's good for the goose is good for the gander." All right. A federal grand jury indicted President J. Trump on 4 counts for
I'm gonna move it
conduct.
over a little bit.
Oh, okay. Now, some people say that John actually makes Dark and I read these things because he enjoys us flubbing the complex words. A federal grand jury indicted former President Donald J. Trump on 4 counts for conduct.
I think Rich might have froze up here. A federal enjoy. Am I frozen up or is it Rich? Which one of it? Can you guys let me know? Okay. Basically, what is going on is that, okay, I'm not going to read the whole thing because I hate reading out loud. But what is going on here is basically anything done in the constitutional duties of the president give the president immunity. So therefore, anything that the president cannot be charged from from anything he's done in office as long as he's doing it in his official duty. Now, let's say he goes unconstitutional and does something that's unconstitutional or not allowed in the official duty. He does not have protection from that. So I'm going to start reading here a little bit, then we're going to go off. A federal grand jury indicted President Donald J. Trump on 4 counts of conduct during his presidency following the November 2020 election. The indictment alleged that after losing the election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of the election results. Trump moved to dismiss the indictment based on presidential immunity, arguing the president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibility, and the indictment allegations fell within the core of his official duty. The district court denied Trump motion to dismiss, holding that former presidents do not possess federal criminal immunity for any act. The DC Circuit Court affirmed. Both the district court and DC Circuit Court declined to decide whether the indicted conduct involved an official act. All right, go ahead, Rich.
Let's see. We're
Held.
are are we starting at under our constitution?
Yes. Oh man, Monday, right? Okay. Under our constitutional structure of separated powers, the nature of the president's power entitles the former president to absolute immunity. Here comes Rich. From criminal prosecutions for actions within his conclusive and pre-conclusive constitutional authority, and he is entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts. Basically, what that is saying is that anything done while in the office of the presidency, he cannot be prosecuted for. Now, let's say he's a president and goes robs a store or does something that's not under his official office of presidency, like he does some type of I don't know, like crypto scheme or something like that. Well, it's up Paul from Legally Armed America, then that means that he could be prosecuted because of that. But
So if he gets a speeding ticket,
yes, but since this was a criminal prosecution for something that he did under the official office of the presidency, he cannot be prosecuted for it because he has immunity. I would like to state that this has been kind of what it's been understood as for a long time. In fact,
for centuries.
Richard Nixon was not prosecuted for his acts that were obviously unlawful, breaking and entering, and like that.
So Nixon wasn't impeached. He stepped down before he was impeached.
Yeah, but he was not prosecuted at all.
Right. Correct. So now, does this give Trump immunity in the documents case in Florida?
That would have to be argued separately. But
it sounds like it does.
It does lay a case for that.
Mm-hmm.
All right, go with A.
This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency, determining whether and under what circumstances such a prosecution may proceed requires careful assessment of the scope of presidential power under the Constitution. The nature of that power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office, at least with respect to the president's exercise of his core essential powers. This immunity must be absolute. As for his remaining actions, he is entitled to at least presumptive immunity. Article 2 of the Constitution vests executive power in a president of the United States of America. The president has duties of unrivaled gravity and breadth. Trump versus Vance, his authority to act necessarily stems from either an act of Congress or from the Constitution itself. Youngstown Sheet and whatever case law in later case, the president's authority sometimes conclusive and preclusive. When the president exercises such authority, Congress cannot act on and courts cannot examine the president's actions. It follows that an act of Congress, either a specific one or targeted at the president or generally applicable one, may not criminalize the president's actions within his exclusive constitutional power. Neither may the courts adjudicate a criminal prosecution that examines such presidential actions. The court thus concludes that the president is absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority.
Okay. Wow. Basically, it's basically like qualified immunity for the president.
Correct.
But the cops have a lot of cops, which I'm actually against, have qualified immunity. For the president, I take a little bit different stand than what I do for the cops, because if you start prosecuting presidents, you're going to open up a Pandora's box where it's not going to be good, where every time a president gets out of office, they get prosecuted, because anytime the president does something, there is something that it could be construed either way. For example,
Right.
Assassinations are illegal, but Osama bin Laden, there was a kill order on him to kill him, not take him hostage and not capture him, but actually kill him. So that would mean, even though I agree with that decision, that means Obama could be charged with, ordering an assassination, which is against the
But
law.
if Obama ordered the assassination of Big Mike's ex-boyfriend, that would be wrong.
Yeah, yeah. But there's certain things like that. I think it's very dangerous to prosecute political rivals.
Right.
And I'm pretty sure that the whole Trump thing, I'm not a Trump fan at all. Rich is, I'm not. But I'm pretty sure the whole Trump thing is politically motivated to try to get him off the ballot.
Well, all of these quote unquote crimes existed for years, and he didn't get prosecuted on any of them until he announced that he was running. So that would lead me to believe that it's politically motivated.
I believe it's politically motivated, but go ahead and read.
The framers designed the presidency to provide for a vigorous and energetic executive. The Federalist, number 70.
Yeah, that was written by Alexander Hamilton of the famous.
They vested.
Just
They,
joking.
they vested the president with supervisory and policy responsibilities of the utmost discretion and sensitivity. Appreciating the unique risks that arise when a president's energies are diverted by proceedings that might render him unduly cautious in the discharge of his official duties, the court has recognized presidential immunities and privileges rooted in the constitutional tradition of the separation of powers and supported by history. In Fitzgerald, for instance, the court concluded that a former president is entitled to absolute immunity from damages and liabilities that acts within the outer perimeter of his official responsibility. The court's dominant concern was to avoid diversion of the president's attention during decision-making process caused by needless worry as the possibility of damages actions stemming from any particular official decision.
Okay, basically what this is saying is, let's say the president let's say there's a terrorist and he's golfing on a golf course, or I don't know, maybe the military reports that they have him targeted by a drone. No, this is a hypothetical. It never actually happened under Clinton or anything with Osama bin Laden. But Clinton or the president decides, well, I don't know if I'm going to be prosecuted if I take out this terrorist guy, even though it could prevent the deaths of thousands and thousands of people. So they worry about it so much that they don't take action to kill this terrorist because they're worried that they get prosecuted. What they're saying here is that, you have to have some immunity, or when the president needs to act, he might hesitate because he is worried that it will fall back on him and end up in prison. All right, go ahead.
By contrast, when prosecutors have sought evidence from the president, the court has consistently rejected presidential claims of absolute immunity. During the treason trial of former President Aaron Burr, for instance, Chief Justice Marshall rejected President Thomas Jefferson's claim that the president could not be subjected to subpoena. Marshall simultaneously recognized, however, the existence of a privilege to withhold certain official papers. United States v. Burr, and when a subpoena issued to President Richard Nixon, the court rejected his claim of absolute privilege, but recognizing the public interest in candid and objective and even blunt or harsh opinions in presidential decision-making. It held that a presumptive privilege protects presidential communications Because that privilege relates to the effective discharge of a president's powers, the court deemed it fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution. Criminally
Basically, that's just saying that there's no absolute immunity to every action that the president takes, but there is a wide berth given to presidential actions, and the presidential actions that are under the official office of the president is
all right. So now, does this only deal with presidential immunity? What about his cabinet staff? Does this fall onto them also?
If you read what it said, that was the treason trial of Aaron Burr, who was vice president. So that should answer your question.
Okay. So because Steve Bannon reports to jail today, right?
Yes, he does, but that is for
Contempt of Congress, was it?
Yeah, that's a little bit different. Contempt of Congress is something that is a little bit different. There is a bill to go ahead and go after Merrick Garland for contempt of Congress.
Yes.
That's up right there, and I don't think that would protect Merrick Garland.
Okay. Criminally prosecuting a president for official conduct undoubtedly.
Wait. Also, let me just point out this. This talks about subpoenas in there too. Basically, they're saying that the executive branch could be subject to subpoenas.
Okay. Criminally prosecuting a president for official conduct undoubtedly poses far greater threat of intrusion on the authority and functions of the executive branch than simply seeking evidence in his possession. The danger is greater when what led the court to recognize absolute presidential immunity from civil damages and liability, that the president would be chilled from taking the bold and unhesitating action required of an independent executive. Although the president might be exposed to fewer criminal prosecutions than civil damage suits, the threat of trial, judgment, and imprisonment is far greater deterrent than plainly more likely to distort presidential decision making than the potential payment of civil damages. The hesitation to execute the duties of his office fearlessly and fairly that might result when a president is making decisions under a pall of potential prosecution, raises unique risks to the office of the executive functioning of government, but there is also compelling public interest in fair and effective law enforcement. Taking into account these competing considerations, the court concludes that the separation of powers principles explained in the court's precedent necessitate at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibilities. Such an immunity is required to safeguard independence and effective functioning of the executive.
Yeah, basically what they're saying is that if you give too much power to the courts to prosecute the president, then it's bad. Okay. I'm just going to go a little bit further down here. I'm going to jump down to, because this is a decision that's 118 pages. We're not going to read it through all 119 pages. So start from here and just read a little bit of this.
From January 2017 until January 2021, Donald J. Trump served as President of the United States. On August 1st, 2023, a federal grand jury indicted him on 4 counts of conduct that occurred during the presidency following the November 2020 election. The indictment alleged that after losing the election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of election results. According to the indictment, Trump advanced his goal through 5 primary means. First, he and his co-conspirators used knowingly false claims of election fraud to get state legislators and election officials to change scroll down,
I am.
electoral votes for Trump's opponent, Joseph R. Biden Jr., to electoral votes for Trump. The indictment, second, Trump and his co-conspirators organized fraudulent slates of electors in 7 targeted states and caused these fraudulent electors to transmit their false certificates to the vice president and other government officials to be counted at the certification proceedings on January 6th. Third, Trump and his co-conspirators attempted to use the Justice Department to conduct sham election crime investigations to send a letter to the targeted states that falsely claimed the Justice Department had identified significant concerns that may have impacted the election outcome. Fourth, Trump and his co-conspirators attempted to persuade the vice president to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. And when that failed on the morning of January 6th, they repeated knowingly false claims of the fraud gathered. Two gathered supporters falsely told them that the vice president had the authority and the might to alter the election results and directed them to the Capitol to obstruct the certification proceeding. Fifth, when a large angry crowd violently attacked the Capitol and halted the proceedings, Trump and his co-conspirators exploited the disruption by redoubling efforts to levy false claims of election fraud and convince members of Congress to further delay the certification.
Yeah, whenever you see that's not Judge Roberts actually stating that. He's quoting from the lawsuit.
This is not considered fact.
No.
This is claims.
Yeah.
Based on all this alleged conduct, the indictment charged Trump with conspiracy to defraud the United States in violation of law, conspiracy to obstruct the official proceeding, obstruction of an attempt to obstruct official proceedings in violation of conspiracy against the rights in violation of whatever, 241. Trump moved to dismiss the indictment based on presidential immunity. In his view, the conduct alleged in the indictment, properly characterized, was that while he was president, he, 1, made public statements about administration of the federal election, 2, communicated senior Justice Department officials about investigating election fraud and about choosing the leadership of the department, 3, communicated with state officials about the administration of the federal election and their exercise of official duties with respect to it, 4, communicated with the vice president and with members of Congress about the exercise of their official duties regarding the election certification, 5, authorized or directed others to organize contingent slates of electors in furtherance of his attempts to convince the vice president, to exercise his official authority in a manner advocated by President Trump. Motion to dismiss indictment based on presidential immunity. Trump argued that all of the indictment's allegations fell within the core of his official duties, and he contended that the president has absolute immunity from criminal prosecution from actions performed within the outer perimeter of his official responsibilities to ensure that he can undertake the especially sensitive duties of his office within bold and unhesitating action. The district court denied the motion to dismiss, holding, and I'm counting on Crump to scroll up, but he's busy at the moment. And if only I had my own copy of this document. Let's see. So what they're saying here is Trump, within the core of his decision making, is 100% immune. Now, if he does things in the perimeter of his core, they're saying he has the not 100% immunity, but he has limited immunity and has to be considered immune before it's proven otherwise. And basically, if he's riding down the road at 100 miles an hour, he's guilty of speeding. So that's what this is saying, and this is going to some of the points that they're making against Trump and just listing them. And we're still reading through that portion, and we're going to be getting to the portion where the actual decision is. Now, Roberts, as the Supreme Court justice, is typically, he's not conservative. He'll typically, change a little bit. That former presidents do not possess absolute federal criminal immunity for any acts committed while in office. The district court recognized that the president is immune from damages, liability in civil cases to protect him against chilling effect such exposure might have on carrying out his responsibilities, see Nixon versus Fitzgerald. But it is reasoned that the possibility of vexatious post-presidential litigation is much reduced in the criminal context in light of the robust presidential procedural safeguards attended to federal criminal prosecutions. The district court declined to decide whether the indicted conduct involved official acts. And we need Crump to scroll up again. So Roberts is Chief Justice of the Supreme Court, and he made this decision. Crump, we need you to scroll up a page. Oop. Let's see. Trump moved to dismiss the indictment based on presidential immunity. In his view, the conduct alleged in the indictment, properly characterized, was that while he was president, 1, made public statements about the administration and the federal election, 2, communicated with senior Justice Department officials about investigation of the election fraud, about choosing the leadership in the department, 3, communicated with the officials about the administration of federal election and their exercise of official duties with respect to it, 4, communicated with the vice president and with members of Congress about the exercise of their official duties regarding the election certification, and 5, authorized or directed others to organize contingent slates of electors in furtherance of his attempts to convince the vice president to exercise his official authority in a manner advocated by the President Trump. Grumpy, we need to move up. So this is interesting that Roberts wrote the opinion, and we're going to get to the opinion portion shortly. I'm not a big fan of Roberts. He is not a big conservative. Crump, we need to roll up. And I think we've seen this paragraph before.
Sorry, dealing with day jobs, trying to report on this. I got called into a meeting as I was going live.
Yep. I hear you, man.
The district court denied the motion to dismiss, holding blah, blah, blah. Okay, let's just wrap this up here. Basically, it was a 6-3 decision, and they decided that Trump does have immunity through this case.
Hold on. Was it Tarzan Brown Jackson, Kagan, and Sotomayor that went against the other 6?
Of course. But yeah, I think this is totally a case just to go ahead and try to get Trump off the ballot. One of the things that I do want to point out is tomorrow at 9:30 we might have another breaking news story because there's an order list coming out tomorrow, and we are expecting the Illinois assault weapons ban to either be granted or denied cert,
Oh,
and
sure.
also Antioch to be granted or denied cert. So that
Hmm.
might be something that we are looking forward to. But we are going to get out of here so I can get back on this meeting. Just wanted to, I know this is not gun related, but it is still an important thing that does affect gun stuff. So I wanted to cover it. I was debating whether to cover it or not, and we decided to go ahead and cover it.
Ready, Crumpy? So Antioch is what case?
That's a challenge to the New York Concealed Carry Improvement Act
They got to go with that.
and the Illinois assault weapons ban.
Okay. Alrighty.
So we'll find out what is going on, and then we will move on from there. And hopefully, we'll have a couple of new cases to look forward to. There is the Franklin Receivers case, the Vanderstock case, which the Supreme Court did take up, and that is probably going to be a slam dunk for us because a couple different reasons, a couple
Chevron.
different cases in this, the cargo case, which deals with APA, is going to be used heavily in Vanderstock, and also Chevron, the Chevron case, the Looper Enterprises case, which Looper Bright Enterprises, which killed Chevron, and they used Chevron for that as well. So that case, which will be heard the next session in the fall, that should be pretty much a slam dunk. I have no idea how the ATF is going to try to fight it because there are two reasons that they were using that they have are now dead and gone thanks to this session. It's all connected, man. It's all connected. So we'll see what happens with that, and we will keep you updated on that. But that's going to be good. It's we should have a lot more answers. And in fact, one of the cases, the Cargill case, where they admitted that assault weapons like the AR-15 are in common use, should actually help out the case as well if they stick with Heller, which I'm sure they're not going to overturn Heller because they don't have the power to overturn Heller right now. So we'll have to see what goes on here. I want to thank Rich for coming on and helping me with this, especially since I got called into a meeting as I was going. And no, I'm not a Boogaloo boy. I got this shirt in Hawaii.
I don't think that absolves you of that.
Oh, but there's one other thing I want to bring up.
But wait, there's more.
Yeah, I was just thinking about this just now. If the Democrats could prosecute Trump for claiming that the election was stolen, couldn't they prosecute Clinton? They still can prosecute Clinton because she was never president.
Correct.
For claiming
so there's no presidential immunity to her.
No, but I still don't think that, I don't think it does any good.
And who's the president? Governor of Georgia in exile. What's her name?
Oh, Abrams.
Susie yes, Stacey Abrams.
Stacey Abrams. Yeah, but I still don't believe that they should be prosecuted for saying an election is stolen. I think that is the right to assume that.
Everybody said that. Every loser would be in jail. Let me put it that way.
Well,
except Reddit or
should be in jail, but it also states that that you can't question something, which I think is dangerous.
Absolutely. I think scientific method determines that you have to question everything. Period. Even Fauci.
I mean, if you're not allowed to question things, then
you'll never learn.
Really free? No.
And I believe a vigorous debate of facts is critically important. That people are presented with the facts and are allowed to choose for themselves and aren't told what to choose.
Exactly, which is something that the government, especially under Biden, have been pushing for. Or under whoever's running the actual government. I'm not even sure who it is. I'm
So
sure. I don't think it's Kamala Harris.
no, Kamala Harris was chosen because she was the biggest VP loser. She didn't even make it to the first primary,
So,
and she was chosen because she could be easily controlled.
so who was actually running the government? That's the question.
Jill Biden.
I don't think it's Joe Biden either. I don't know who it is.
Whoever's whispering into Biden's earpiece.
Maybe. I guess his earpiece must have broke last week, or he just didn't know who was talking to him, and I don't know. Yeah.
Do you know the DNC said he overprepared and he was overtired, and that's why he didn't perform well. And he had a cold.
And he beat Medicare. Whatever the hell that means. My favorite line was Trump was like, I'm not even sure what he said. I'm pretty sure he doesn't know what he said.
Wow. I hope there's a golf off.
Yeah, I mean, that was ridiculous. The whole golf thing was ridiculous. But other than that, let's go ahead and wrap up here. Thank you guys so much for watching. I'll be back later on. And yes. Oh,
We're doing John Crump Live today?
Yes, I think we'll help. Check out Gun Day Morning QB. He does have a book on Amazon. It's pretty good. It's called Rules for Thee on Amazon. It's a good book. So go ahead and definitely check it out. And with that, we are out of here. Thank you so much. And I will talk to you guys later. Bye.